I've been divorced from my ex for 4 years. We lived in Louisiana at the time of the divorce, and he allowed me to move 4 hours away to Texas to be closer to family if I agreed to give up alimony. Over those years, he saw our children minimally. They are now 13 and 11. I have primary custody. He got every other weekend, which turned into once every month or two, and he was paying child support. This summer, he moved 5 minutes away from us to see the kids more, which I commend. He said at the time that he would like to do 50-50, and he stopped paying child support. I agreed to try this for the benefit of my children. Well, fast forward 5 months later, and he's not doing 50-50. I would say we're currently doing 80-20, and that's being kind. I do not fault him completely. Our children do not wish to do 50-50 and are resistant to spending time at his home during the school week. Should I take him back to court to establish some child support? When I tried to discuss this with him, he told me he would move back to Louisiana again if he has to pay, and I don't want our kids to be without their dad again. Hi, my name is Billy Tarasio, Arizona family law attorney, owner of Modern Law, and Win Without Law School. This is a fantastic question, so I just want to talk you through this here. I'm assuming at this point what you would have needed to have done is taken the order from Louisiana, registered it in Texas, and then asked Louisiana to release jurisdiction or ask Texas to take jurisdiction over your case. Then you would have needed to have filed a change in order, a modification to the parenting time and the child support also in Texas. So I'm assuming that your current order is in Texas. And now what you're wondering is whether or not you should file for child support since he's not using the time in the current order. If this case were in Arizona, I would not advise you to do that. I would tell you that you need to file to modify the parenting time because child support is ordered based on the ordered parenting time credits, not what's actually being used. So many times people make this mistake. They file to change child support based on what's actually happening with parenting time, but they don't actually file to change parenting time, and you have to file to change parenting time. So what you would do is you would file to modify parenting time and modify child support based on the fact that he's only taking them 20% of the time. Then the court would have to agree that that was in the kid's best interest, order 80-20, and then order your child support for 80-20. Now he's saying, I'll just move away and not do 20%. That's only going to make his child support go up. That doesn't relieve him of his obligation to do child support. So what's really going to happen here is either he's going to do 50-50, which you don't want and your kids don't want, in order to avoid child support, or he's going to pay child support, one way or the other, whether he lives in Texas or in Louisiana. So you just have to decide, is this worth it for you? Are you going to do it yourself? If you are doing it yourself, check out Win Without Law School. We can help walk you through all of these steps. Or is it not worth it? And so I would definitely run a child support calculator and figure out what we're talking about and then see if you can negotiate something. And depending on, you shouldn't not get child support if you need child support, but you should also do a really thorough analysis of whether or not it's worth it. I hope that helps.